So the topic for today is offenses against human body and particular focus in the newly enacted Bharatiya Nyaya Sanhita. What I wish to canvas right now is not the entire and overall all the offenses with respect to human body, but particularly what all has in fact changed in this Bharatiya Nyaya Sanhita. Before I start with that, I would like to say that in the earlier Indian Penal Code, we had one chapter dealing with offenses against human body. Now, that chapter was chapter 16 in the Indian Penal Code. In that, you had offenses against human body, offenses against children, offenses against women, etc., etc. What they have done now in the Bharatiya Nyaya Sanhita is that they have bifurcated this offense. Firstly, they have introduced chapter 5, which deals specifically with offenses against women and children. And secondly, you have offenses against the human body. Today, we'll concentrate on chapter 6, which is offenses against human body. Now, all of us are aware that offenses against human body predominantly would include something like murder, hurt, grievous hurt, attempt to murder, abetment of suicide, and the likes. Now, I do not want to get into each and every offense because I believe most are either lawyers or either law students who may already know or have already learnt what murder is, what culpable homicide amounting to murder is, what culpable homicide not amounting to murder is. So I would refrain from getting into that hole for the sole reason is that there is so much which has changed in the Bharatiya Nyaya Sanhita from the Indian Penal Code, which needs to be canvassed, and that will also take a considerable amount of time. Now, let's start with the offense of murder. The definition of murder, nothing has changed. The definition of culpable homicide, nothing has changed. So basically, whatever you have learned in the IPC continues to be the same in the PNS. What has changed here is rather not a change, it's a welcome addition, is in the punishment of murder. Earlier, punishment for murder was 302, which was famously 302 IPC. Now, the punishment for murder has changed from 302 to 103. Punishment also largely remains the same, which is firstly death or imprisonment for life. But there is a subclause added, that is 103 subclause 2. Now, what does this subclause say? When a group of 5 or more persons acting in concert commits murder on the ground of race, caste, or community, sex, place of birth, language, personal belief, or any other similar ground, each member of such group shall be punished with death or with imprisonment for life. This, what we essentially call, is mob lynching. You must have all heard there are many cases nowadays in the news. You hear people getting lynched by the mob for various other reasons. It may be because of caste, creed, religion, or any other sort of things. Now, what the legislature has introduced is 103 subclause 2, which is mob lynching. Now, you may ask, why this addition when the punishment remains the same? The addition is basically that murder, of course, you conspire to murder, etc., etc. When you talk about mob lynching, more often than not, there is no conspiracy per se. There may be common intention, but there is no conspiracy per se. Now, in that common intention, when a group of 5 or more people, all right, acting in concert. What do you mean by acting in concert? That means they are doing this together. Regardless of their role, regardless of how much one contributes to this, as long as there are 5 or more people for committing this particular offense. Now, when there are 5 or more people committing an offense of murder, you can call it mob lynching. However, here again, the legislature has added one more caveat. Firstly, you need to commit murder. Secondly, you need to be more than five people. And thirdly, what you need is that you murder the person on the ground of race, caste, community, sex, place of birth, language, personal belief, or any other similar ground. Only if you fall under these categories can you be held up for an offense of mob lynching. Now, one may ask that this pretty much suffices everything and covers everything, especially the words or any other similar grounds. I mean, of course, the courts are open to interpret right now, and now it's very nascent. So we've not had much interpretation on this subject. However, in my opinion, this restricts it to these categories. Of course, or any other similar ground will have to be similar to the other previously mentioned ones. It can't be anything else. I'll give an example. Now, oftentimes what happens is that suppose there is a theft at someone's house or at some workplace, etc. Now, many a times we see cases where five or more people thrash the thief to such an extent that that person dies. Such a particular case where a person who may not even have stolen anything, may have even been accused of stealing something, or may have even been accused of maybe harassing someone, or any of those, or maybe untrue as well. But these five people or more people coming together and beating up that person so badly, which may amount to the death of that person, will not amount to mob lynching. It may come to murder, and depending on the roles of each person, they can be categorized as to who is for murder, who can be uh, for conspiracy, or whatever the other offenses. But mob lynching by itself will not be applicable in such a manner. So, in my opinion, the legislature could have widened the scope, but of course, we have the courts which will now interpret this section and may give a wider meaning to it. So let's hope for that. Now, speaking about mob lynching, now this we've done with the murder part of it. Similarly, in section 1174, and what is 1174? 117 is equivalent to the grievous hurt sections. All right. Now, voluntarily causing grievous hurt is 117. That was earlier 326 of the Indian Penal Code. Now, 325, 326. 325 was the definition, 326 was the punishment. Here again, they have added the same thing. When a group of five or more persons acting in concert causes grievous hurt to a person on the ground of his race, caste or community, sex, place of birth, language, personal belief, or any other similar ground, each member of such group shall be guilty of the offense of causing grievous hurt and shall be punished with the imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. Now, as we saw, similarly, in murder, and now the same concept of mob lynching for the offense of grievous hurt. So this is a slight change, or rather an addition in the BNS, which has been added by the legislature. And I believe it's a welcome change in the increasing times we keep hearing about these mob lynching incidents which happen across the country. I believe that this is, in fact, very helpful to curb such mob lynching incidents in our country. Now, moving on to the next change. Okay. Apart from this change in murder and grievous hurt, there is not much. Everything remains the same. Our definition for murder, culpable homicide, what does not amount to culpable homicide, what amounts to culpable homicide is all the same. Now, jumping to the next change, which is a change in section 106, which was 12304A, that is death by negligence. Now, what is death by negligence? Everybody knows that there's a difference between causing murder and causing death by negligence. A person driving rashly may end up running over someone, that other person may die. this is death by negligence because of that person's negligent act. Something of this sort has happened. Now, mostly hit and run driving cases are mostly the ones which are usually charged with 304A. Of course, there are many other situations where 304A can be charged with, but this is more or less just to give an example. Now, what is the addition? The addition in this is 106 part 2. 106 subsection 2. What does this read as? Whoever causes death of any person by rash and negligent driving of vehicle not amounting to culpable homicide and escapes without reporting it to the police officer or a magistrate soon after the incident shall be punished with an imprisonment of either description which of term which may extend to 10 years. Before I go on to this, I want to deal with the first subsection, which is whoever causes death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with imprisonment which shall uh, imprisonment of either description for a term which may extend to 5 years and shall also be liable to fine. And if such act is done by registered medical practitioner while performing medical procedure, he shall be punished with an imprisonment for 2 years. So what the legislature has done, it has increased the punishment from 2 years to 5 years and added a second subclause. Now, the second subclause, which I have already read out, only deals with a situation, all right, with respect to negligent driving of a vehicle. It does not include any other such situation. Now, what does it say? Any person by rash or negligent driving a vehicle not amounting to culpable homicide and escapes without reporting it to the police officer or a magistrate soon after the incident shall be punished with a term which may extend to 10 years. In the first subsection, you could have committed the committed the death by a negligent act and gone and reported to the magistrate. The second part deals with hit and run. Now, whoever had followed the news right before BNS came into picture, there was a statewide or other nationwide protest by truck drivers, etc., with respect to 106 part 2. And they had objected to this, saying that it's a very bizarre and arbitrary distinction you are drawing between the two people. Hence, the government has not notified 106 subsection 2 till now. So basically, 106 subsection 2 is not in action as of today. And it may or may not come in future. But what also gives rise to this particular section to not be notified is another thing. So all of us are aware that a person, or rather an accused person, has a fundamental right, rather, a right to remain silent, guaranteed to him under Article 20, subclause 3. A right to remain silent is a very, very important and potent right which which a accused has. Now, this section, what it does is that it tells you to go and admit to your crime before the magistrate, saying that I have done it. So please don't punish me under subsection 2, punish me under subsection 1. This will also be in contrast with 106 subclause 2. Because a statute cannot compel you to go and admit to your offense. In effect, 106 subclause 2 is asking you to go and admit to your offense. So my personal belief is that whenever this section, if at all it is notified without any amendment, could be under challenge only because it is violative of the fundamental rights of an accused guaranteed under Article 20 subclause 3. And the courts will then have to decide whether 106 subclause 2 is ultra vires the Constitution of India, especially the fundamental rights, and accordingly would have to be struck down or amended, whatever the reason may be. But this is my opinion right now. However, it is not yet notified, so it doesn't matter. because it can never be, no person can be charged with 106 subclause 2 as of now. Now, one more interesting change, one more interesting missed opportunity rather, is with respect to abatement of suicide. When lawmakers were uh, charging people, when police was charging people with abatement of suicide, we've all seen during COVID with respect to Sushant Singh Rajput and Riya Chakrabarti case and Arnab Goswami case. There are many instances wherein there are cases of abatement of suicide, and the Supreme Court has taken a very strict use of abatement of suicide. So those particular guidelines laid down by the Supreme Court with respect to how do you abet someone's suicide, that has not been introduced in the BNS, which have been missed out. One more thing which has been removed from the BNS, which was an offense earlier in the IPC, was attempt to commit suicide. Okay. So attempt to commit suicide was struck down, not struck down, was rather eclipsed by the Supreme Court in the judgment of Navtej Johar, wherein the Supreme Court said that under the Mental Illness Act, there is a provision that if a person who is attempting to commit suicide is not mentally stable, and hence it cannot be an offense which it cannot be an offense under which it can be charged, and they can get a go by or rather a defense under that particular mental act. And hence the Supreme Court has in effect eclipsed attempt to commit suicide, and now we are done away with it. There is no offense of attempt to commit suicide in the BNS. Now coming to the next, organized crime. Now what is organized crime? Basically, in Maharashtra, Gujarat, and many other states, you always had this particular statute called, in Maharashtra, it was the Maharashtra Control of Organized Crime Act. All right. What does this act do and why was this implemented? During the Bombay blast in 1993, there was an uproar of terrorism, terrorist activities. More than terrorist activities, it gave rise to a lot of gangs to be formed and gangsters which had come up during the 90s in Bombay. So the legislature of Maharashtra deemed it fit to introduce a special act to deal with such a mob or such a gang wars, gang leaders, etc., for the purpose of curbing such activities. Then the legislature introduced something called as the Maharashtra Control of Organized Crime Act. Now, after this was introduced somewhere in 1999. Now, the Maharashtra Organized Crime Act, which is commonly called as the MCOC Act, in that there is a special procedure prescribed. That means there is a different procedure for bail, there is a different procedure for recording evidence, there is a different procedure for recording statements of the accused, and many other such. There is a different thing for, there is a bar to grant anticipatory bail, and there are many other such procedures laid down in that. So it's basically a code in itself, and when an act is punishable under the MCOC Act, you have to follow that particular code. What the central legislature has now done is that they have also introduced this. Now there is some difference between the two. Now let's understand the difference. Now, if you see the MCOC Act and the definition of organized crime, there, organized crime means, in MCOC Act, it means any continuing unlawful activity by an individual, singly or jointly, either as a member of an organized crime syndicate or on behalf of such syndicate, by use of violence or threat of violence or intimidation or coercion or other unlawful means with the objective of gaining pecuniary benefits or gaining undue economic or other advantage for himself or any other person, or promoting insurgency. Now, what is important to note here is that MCOC used to apply only for the purpose of by use of violence or threat of violence or intimidation or coercion. However, if we see the change right now in organized crime, how is it defined under section 111 of the BNS, which is any continuing unlawful activity including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offense, cyber crimes, trafficking of persons, drugs, weapons, or illicit goods or services, human trafficking for prostitution or ransom by any person or a group of persons acting in concert, singly or jointly, either as a member of an organized crime syndicate or on behalf of such syndicate by use of violence, threat, intimidation, coercion, or by any other unlawful means to obtain direct or indirect material benefit. Now, the first part which has been added in section 111 is with respect to any continuing unlawful activity, including kidnapping, robbery, vehicle theft, etc. They have also included economic offenses. Okay. And they have defined economic offenses later, which say that includes criminal breach of trust, forgery, counterfeiting of currency notes, bank notes, government stamps, hawala transaction, mass marketing fraud, or running away any scheme to defraud several persons, or doing any act in any manner with a view to defraud any bank, financial institution, so and so. Now, of course, as you may notice that there is a difference between the definitions. That is, this organized crime under BNS expands the scope to even cyber crimes, economic offenses, and traffic, etc., which was not part of the MCOC Act. But what the legislature has missed in this, which misses me and which it will come to light now with time to come, is that now there is a state act punishing organized crime, and now there is a central act. Now you may ask that why are there two acts in place, and if there are two acts, which one would prevail? Now, if the state act is repugnant, that means if some part of it is contrary to that, then as per Article 251 of the Constitution of India, the state act, whether enacted before or after, does not matter, and the state act will lie behind and the central act will take precedence over it, because it's assumed that the center is aware of the state acts and then the center makes such a law. Now, in this present scenario, MCOC and GCOC, which is Gujarat, etc., already had their laws in place. In spite of that, the central government has now come out with the Organized Crime Act. Therefore, of course, both are in the concurrent list. This topic is in the concurrent list of making these offenses. Hence, both union and the state have the right, or rather power, to enact such a enactment, such as the Organized Crime Act. In this case, the center has enacted organized crime. In my opinion, if there is any conflict, of course, the central act will obviously overrule the state act. Hence, we will still have to wait and watch till the time to come just to see that which act will take precedence and whether the courts will hold that the central act will take precedence over the state act, because there are these slight changes which are very minute in nature, because more or less by and large it amounts to the same thing. Now, I do not want to get into explaining what organized crime is, but just in brief, as I already told you, it is to curb the gang war and this. They have also defined what an organized crime syndicate is. Now, what is an organized crime syndicate? A group of two or more persons who acting either singly or jointly as a syndicate or a gang indulge in any continuing unlawful activity. Now, these people can be two or more or however. Now, they can either act together or can be differently. Now, for example, let's take a particular gang leader, gangster A. Now, every gang member of that gang leader will not be involved in every offense. There may be some members of that gang who are involved in a different offense and some in the different offense. That does not mean that they are not part of that crime syndicate. Hence, MCOC or Organized Crime under 111 will apply to them. Now, the last words we read here is for indulging in any continuing unlawful activity. Now, what is a continuing unlawful activity? That is also defined in the BNS. Means an activity prohibited by law which is cognizable offense punishable with imprisonment of 3 years or more undertaken by any person either singly or jointly as a member of an organized crime syndicate or on behalf of such syndicate in respect of which more than one charge sheet have been filed before the competent court within the preceding 10 years. What does this mean? Of course, it means that whatever act they are committing, it needs to be for an offense which is punishable for more than 3 years. It cannot be or for a petty offense or otherwise, which is below 3 years. That being said, MCOC can only apply to a gang wherein against which or against whom two or more charge sheets have been filed, which is pending before the competent court. Now you may ask, it is not that every person who is charged with this offense shall have two or more charge sheets. It is that any person in the gang shall have two or more charge sheets as long as one can demonstrate what an organized crime syndicate or an organized crime gang is. And any person in that gang having more than two offenses against them shall be punished with this provision. Now moving on, there is also petty organized crime. As I said, this is 111 was for offenses of 3 years plus. 112 talks about petty organized crime, which is whoever being a member of a group or gang, either singly or jointly, commits any act of theft, snatching, cheating, unauthorized selling of tickets, unauthorized betting or gambling, so and so, will be petty organized crime because it is of a lower level. Now, one more major change which has occurred in this BNS, which was not a part of the IPC at all, is Terrorist Act, is under 113. Now, we already know what terrorism means, a general overview of terrorism. Under the BNS, terrorism or terrorist act is defined as whoever does any act with an intent to threaten or likely to threaten the unity, integrity, sovereignty, security or economic security of India, or with the intent to strike terror or likely to strike terror in the people or any section of people in India or in any foreign country by using bombs, death, injury, etc. There are a series of 5 or 6 examples given. Now, this is a definition of terrorist act under 113. Now, there is another statute which the legislation had enacted way back 1950 or so, I suppose, is the UAPA Act, which is Unlawful Activities Protection Act. Okay. Now, there also a terrorist act is defined. Now, let's see what a terrorist act is defined as in that UAPA Act. Under the UAPA Act, an unlawful activity or a terrorist act is the same as the terrorist act, which is so under section 15 of the UAPA Act, a terrorist act is defined. And it is literally a copy paste of that. Whoever does any act with an intent to threaten or likely to threaten the unity, integrity, security, sovereignty of India, or with the intent to strike terror or likely to strike terror in the people or any section of people in India or in any foreign country, so and so, so and so. So earlier, in fact, in the bill, there was a certain change, but when the act came out, it in fact is a copy and paste of the same. Now, this begs a very important question. Both are central legislations. However, one is a special act, which is the UAPA Act, and one is a general act, which is the BNS. Now, the BNS, being the general act, will not take precedence over a special act as per a settled principle of law. Supreme Court has held time and again in many various other cases that when there is a conflict between a special act and a general act, the special act will take precedence. But what baffles me in this is that the special act was already enacted, was in place, and the general act came later. There is a presumption in law that the legislature is aware of the laws which are already in force. Okay. So it cannot be then questioned that the legislature may not have been aware of the law which is already in force. There is a presumption to that effect, and there are various judgments also to that effect. Now, basically, when there is a presumption and then this 113 is added in the general law, then the question which, of course, comes to everybody's mind is which one would prevail. Of course, as per general logic, I would say that the special act would prevail over a general act, but this general act coming later in point of time would be up for debate in that particular sense, and the courts will decide in times to come as to which act will apply. Similarly, as I said, UAPA Act is also a code in itself. That means it has various procedures, maybe for attachment, it has for bail, it has for many other things, how to record statements of accused, witnesses, this, that, and many other protections and other rules which are not in the BNS because BNS is a general law. So again, there will be a conflict with respect to 113. But however, this is a change in the BNS which has been added. Okay, so now apart from these other bodily offenses with respect to hurt, grievous hurt, etc., all of which remain the same in this chapter for offense against human body. Okay, there is no addition. Now, other offenses would include wrongful restraint, wrongful confinement, which is basically exactly the same. Force, criminal force, assault, everything, kidnapping remains all the same. Now, the scope of today's lecture is not with respect to discussing each and every offense against human body, because I'm sure you must have all learned that whether in IPC or BNS, whoever is a student right now. So I would like to only restrict myself to the changes and also an overview of the BNS with respect to offense against human body. Now, this is offense against human body. Now, there is also offense against, rather, sexual offense. I will also briefly cover that because the reason being that earlier in the IPC, it all fell under one chapter. There was no separate chapter for human body and no separate chapter for sexual offenses. However, only in this there are separate chapters. Now, to discuss in brief, there are only 2-3 changes in the sexual offenses which have taken place. Firstly, is with respect to the offense of rape, which is under 63. Section 63 defines rape. There is no change in the definition per se of rape. Okay, the rape definition remains the same. However, there is a change in the explanation to the definition of rape. Now, 63, the provisos in the definition of rape under the BNS. So basically, we are not done away with the proviso which is with respect to marital rape. However, there's a slight change in that proviso. So we all know that even earlier in the Indian Penal Code, it would not amount to rape if the victim is the legally wedded wife of the particular accused. But there was a slight dispute with respect to the age then, because in a lot of communities, there are people who get married when they are below the age of 18. In such a case, can you then have that conflict of what is that per age of consent or age of. So here in the BNS, they have made the age to 18 years only. Okay. The marital rape punishable up to the age for the proviso to be 18 years of age. Now, a slight change, that's about it. It was in fact already settled by the Supreme Court and judgments in many judgments, but the legislature has changed that. Now, another important change which has happened is with respect to addition of section 69. Okay. Now, what is section 69? It is a newly added section which has been included in the BNS. Now, we may have all heard a lot about offense of promise to marry rape cases. Now, for people who are not aware of what is promise to marry rape cases, I'll just explain it in brief. When a person promises to marry someone and on that pretext has sexual intercourse with some other woman, it is considered as rape because, as per law, it is deemed that you have deceived that person in order to commit rape. Now, this was earlier included and was a part of 376 itself, but now they have made a separate offense for it. Now, in 376, we have also come across in my practice, and I'm sure whoever is a practicing advocate must have come across many cases where there is also a misuse of this section of promise to marry rape cases, wherein a girl and boy who were otherwise in a romantic relationship and would indulge in sexual activity, and suppose if they have a bad breakup or their relationship goes sour, they file such a case only to seek vengeance. So this was very rampant, and the courts have therefore time and again also taken a very lenient view with respect to such cases and do not really categorize that as a rape case, which otherwise is forcible in nature. But that apart, the legislature has acknowledged that this is increased, and that's why the legislature has created a separate category as per section 69. What is 69? Whoever by deceitful means or by making promise to marry to a woman without any intention of fulfilling the same has sexual intercourse with her, such sexual intercourse not amounting to the offense of rape shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Now, interestingly, this is a deviation from the general concept of rape. The legislature has said that this applies to people who have promised to marry without the intention of fulfilling. Okay. However, they have also said that this does not amount to the offense of rape. So basically, this is as I say, like it's not a proviso per se, but it's a sideline of rape. Similar example, like what is a murder, what is culpable homicide amounting to murder, and what is culpable homicide not amounting to murder. So this is sexual intercourse not amounting to rape, and whereas in 63 it is sexual intercourse amounting to rape. So that is the difference which is drawn out by the legislature for introduction of this particular section. It is of course given a lesser punishment, that is a term which may extend to 10 years as opposed to death or life, which is for the offense of rape. This is 10 years, up to 10 years. But mostly for lawyers here, there may be an interesting question, law point, which can arise with respect to section 69. Basically saying that when there is deceit involved, okay, it must amount to rape, because what is rape? It's sexual intercourse apart from other things without the consent of the person. Now, when there is deceit involved, you can say that there was no consent. Therefore, it is obvious that it is rape. But when the legislature has now drawn out a separate category of deceit, can that then amount to rape? Is a big question mark, which again the courts in time to come will have to answer such questions with respect to section 69 of the BNS. But again, of course, this is a change which we need to accept and acknowledge. And uh, lastly, one more thing with respect to sexual offences, which I would like to mention, is that we are all aware of earlier erstwhile section 377, which was part of the Indian Penal Code, which was with respect to unnatural sex. That 377 has now completely been repealed. There was much controversy earlier with respect to 377 with the case of Nas Foundation, then Navteej Johar, etc., where the Supreme Court had decriminalized 377 when the act is consensual. Earlier, every act under 377, which was unnatural intercourse, was punishable. However, the Supreme Court then read it down to mean that only all consensual acts are decriminalized, and only the ones which are non-consensual can come under 377. But here now, the legislature has completely removed 377. Whether it is with consent or without consent is immaterial now. There is no provision or section to punish even the carnal intercourse or otherwise unnatural sex, which is without the consent. So that is something which also needs to be looked into. Now, I would like to conclude this by saying that these were all the changes which had come into picture with respect to sexual offences and with respect to bodily offences, because it was always part of the same before the IPC. And I believe I have more or less covered the changes in the BNS. And of course, we still have to wait and watch to see how the courts react to this and what will happen next. And yeah, thanks a lot, everyone. I would be open to questions if anyone has any questions.
So there's a query in the chat box. Practically, how culpable homicide amounting to murder and culpable homicide not amounting to murder is distinguished? Can you explain with a real case?
Okay, so I'll tell you. Now, I will explain a concept a little bit. Culpable homicide is a big umbrella. What differentiates culpable homicide and not culpable homicide not amounting to murder? That is, now there is culpable homicide means a person is killed. Okay, homicide has caused. Now that can either amount to murder or not amount to murder. Now, giving you an example of a case which I've worked on. There was a man who is standing by near a Pantapri, and he had a family feud with another person. Another person came with two other people, and in broad daylight has stabbed that person about 6 or 7 times and fled the scene. Now, this will be murder. Okay. Why so? Because that person with an intent to commit that particular crime has come with complete preparation to commit that murder. Now, I will give you another example of culpable homicide not amounting to murder, which is in fact one of the explanations also. Now, if a person, a lot of times you see weddings, etc., maybe in some states in India, wherein there is a ritual of, shooting guns. Okay. Now, while you're shooting that gun, if you hit someone and that person dies, you never had the intention to kill that person. Okay. But it becomes culpable homicide not amounting to murder in part two. Why so? Because when you're shooting blindly into the air, you have a knowledge that your act is so inherently dangerous that it may harm some person. So that will amount to culpable homicide, not amounting to murder. because you had knowledge, and that is a lesser punishment of 10 years. So that's basically a difference between one of the cases examples.
Good evening, sir.
Hi, good evening.
Regarding 377, you told that the Supreme Court has decriminalized it, but Supreme Court had decriminalized only partly. That is when it is between consenting adults
Correct.
and say homosexuality between consenting adults. But what they have not criminalized is say homosexuality when there is no consent. Secondly, bestiality, that is sex with animals. Then third is sex with animals and sex with objects. So the Joint Parliamentary Committee, that is Brilal Committee, that submitted a report to the on these three criminal laws to the Parliament. So they had recommended that 377 did not be abolished,
Hmm.
but the government has completely say abolished 377, and it does not find place in the BNS because their logic is that the other four offences are covered under some other that is other sections of chapter 5 of BNS,
Hmm.
and maybe this bestiality is covered in say cruelty to animals act, and the 377 was misused by wives against their husbands,
Hmm.
alleging unnatural sex, and that is the main reason why they have abolished 377 completely, although that doesn't find mention in say any official reports. So do you think it is the reason that 377 could have been abolished completely, that is misuse by wives against their husbands?
No, honestly, that cannot be a reason. If there is misuse, of course, there's a law enforcement agency and the courts which come to rescue for such misuse because, of course, there will be trial, etc. In my opinion, it was not a wise decision wherein you have completely taken off 377. Of course, the consenting part should have remained the same, like how the Supreme Court had decriminalized it. But now let's take a scenario wherein a person has been there is a forceful carnal intercourse from a man to another man. There is nothing in the statutes protecting such a person. Okay, so basically,
Yes.
it may be amounting to maybe just a simple hurt or something of that sort, which may not even be a cognizable offense. So, for such a heinous act, if a man commits rape on another man, of course, it's not defined in rape because rape is only a man to a woman. But if a similar situation happens for a man to a man, there is nothing protecting it. So, in my opinion, it should have been taken into account, but it is not taken into account. So, let's see whether something else comes up or what. But right as of now, there is no such offense.
Yes, and one inconsistency is if you see old 97 and 101, that is right of self-defense,
Hmm.
the 7 and 4 say situations where there is say killing that comes under say self-defense. So in that still under 97, which have been written as it is, except say renumbering of the clauses.
Uh,
So when a man tries to force unnatural sex on another man, so killing comes under self-defense. It doesn't amount to murder. If you see the new BNS also, that
correct.
means although it is not defined as an offense, but the right of self-protection remains. That is, a man can kill another person if the person tries to say unnatural sex with that man without consent. So that is where this right of self-defense is protected under BNS. Thank you.
That's of course, but with respect to the that being an offense itself, there is no other provision. Uh,
Yes, yes. It has been decriminalized fully, and although some parts are covered in Chapter 5, that is sex with objects, and this is already there in the new definition of rape under 63. Similarly, sex with minors, that is also adequately covered, whether with boys or whether with minor girls, that is
hmm.
covered in Chapter 5. And as far as sex with animals is there, I think I'm not sure, but maybe the Cruelty to Animals Act might be covering it
Not,
substantively.
I do not think so. But anyway,
Yes.
doesn't matter. But in this, it's not there. That's the long and short of it. Yeah,
Okay, thank you, sir.
Is there any punishment for necrophilia and bestiality?
that's what we were just discussing. So 27 after being decriminalized, nothing for necrophilia or bestiality remains in the uh, BNS apart from maybe see for necrophilia, of course, no, but for bestiality, maybe some other offenses, as Mr. Virendra Kumar was also mentioning. But yeah, more there's not everything has gone with 377 having gone.
Okay. What are the common evidences in matters relating to abatement to suicide?
Common evidences.
Yeah, I
Mental
maybe probably the participant wants to know any general evidences that are.
So basically, in fact, abatement of suicide is a very strict test. Continuous mental harassment right before the person commits suicide, and not just any mental harassment to an extent which would drive that person to commit suicide. That means that you need to keep telling that person that you need that there is no purpose of his life or her life, and that's one of the evidences. Then, of course, suicide notes are to a great extent admissible in court, and then. Another thing for abatement is when there is a direct abatement, like if someone buys a rope for you to hang yourself, of course, that is also cases where you can be held up for abatement of suicide.
Okay. The next question, what is custodial rape and what is the punishment for it?
Custodial rape, it'll amount to rape only in that definitions are aggravated. Punishment would be death or life. It will be in, I'll tell you, 68, sexual intercourse by a person in authority. That would be 60, section 68 under the BNS. You can read the punishments.
I think yeah, it can be Googled.
68 is
Yeah.
public servant, superintendent of jail, etc. It is amounting to section, not amount, 10 years, etc. Not less than 5 years, etc. etc. That's there in 68. When you can read the entire section, you'll have it clear.
Okay. The next question in matters relating to medical negligence, what are the defenses available to a doctor if the doctor was acting in good faith?
See, in fact, there are judgments to say that whenever a matter is registered under the medical for the medical negligence, then the authorities have to send it to a council of doctors. The council of doctors, with senior doctors or whoever may be, will then decide whether there was negligence in the act, or rather willful negligence in the act of the person of the doctor, or whether it was only during the course of the duty which particular person has done. Because usually there's a lot of misuse because every person wherein the operation has failed, they often put a blame on the doctor saying that there is medical negligence. So there is an entire system drawn out for the medical negligence. Now I'll tell you, for example, if you're asking me an example of willful medical negligence. Now, there are people who are not qualified as doctors who may operate on a particular patient, then that would amount to something of that sort. Then there can be a doctor who's operating upon a particular patient, and when there is a particular prescribed way of conducting that particular operation, a doctor does not do it. Maybe uh, if it is necessary for a doctor to stitch up the organ before closing the patient, and the doctor does not stitch up the organ, and the patient dies of internal bleeding, that is something which can be considered as medical negligence.
Okay. The next question, when we talk about bodily harm, why are we discounting mental injury? Meaning, in cases pertaining to oral or mental abuse, which do not cause physical hurt but cause mental injury to the person.
No, because it's very difficult to prove it. It's impossible for a country in India to have every second person on the road who has a road rage or a fight with any person with respect to parking or throwing garbage or anything will amount to an FIR if that is so. So it will become very difficult to put it in words as to what is mental harassment and what would the test for such mental harassment be. However, there is provisions for cruelty against women in a household, which includes mental harassment. So, with respect to that, in that particular scenario, there is already a provision in the BNS, and earlier also in the IPC, we had that provision. But generally, for mental harassment, there is no provision, or this is not a crime in India.
Okay. The next question, we are into we are 9 months into the introduction of the BNS. According to you, was it needed or the old IPC could have just been amended? What is your opinion?
Honestly, not that my opinion matters in the larger perspective, but in my opinion, I feel that it was not particularly needed. It could have been done with a few amendments because honestly, if you list down all the amendments in the BNS, you will know that it is not too much to be amended. And more or less everything remains the same. So, in my opinion, it could have remained the same, but nonetheless, now it's double work for the lawyers to relearn the provisions of law again. So, I guess that's another challenge.
Okay. The next question, what is the difference between abduction and kidnapping? And if you could give any case law.
No, as a abduction is with respect to an adult, kidnapping is with respect to a child. That's the basic difference between the two. I mean, you can read up. Its example would be the same, like one with respect to there are two kinds of kidnapping, one of a child and one outside the country, and abduction is any other case otherwise. So it's not so much of a difference apart from the person being a kid and the person being an adult.
So I think we're done with the queries. Can we conclude the session?
Of course.
Okay. So thank you so much, sir, for such an illuminating session.
Thank
Yeah,
you.
it was a great learning experience. Thank you.
Thank you so much. Thank you.